This is the Chapter 3 summary. For Chapter 3, they really talked about jurisdiction and the structure of the court systems. For jurisdiction, the thing that stood out the most to me was the subject matter jurisdiction. This is the power of a court to render a decision in a particular type of case, which kind of determines which court the may hear the case. And then for the structure of the court systems, the U.S. is a dual court system split into state and federal laws. Federal has a couple of it has federal trial, intermediate courts of appeal, and court of last resort. And then the state also has state trial courts, intermediate courts of appeal, and the courts of last resort. And so the courts of appeal are just exist in only half the states and have a more broad jurisdiction. And then the courts of last resort are a lot of times referred to as the Supreme Court. Actors in the legal system that the chapter talked about were attorneys, judges, and juries. What stood out most to me was that attorneys have client privilege and work product doctrine, which is basically saying for client privilege they can't say anything without the client's approval, and then for work product doctrine it's any paperwork they can't submit to the court without their client's approval. And then the court, just an overview of how the court hearings usually go. They start with an opening statement and then the plaintiff's case, and then the plaintiff's case is basically the witnesses and the questioning and everything like that, and then the defendant's case, and then they do the conference on jury instructions, they do the closing arguments, and then the post-trial motions. The closing argument, which is the second to last part, is basically the rebuttal, and then they have the post-trial motions. This is the Chapter 4 summary. So for Chapter 4, they really focus on ADRs, which are alternative dispute resolutions, which include negotiation and settlement, arbitration, mini trial, early neutral case evaluation, private trials, and summary jury trials. The ones that really stood out to me were negotiation and settlement, which is where both parties come together to resolve the issue. This includes mediation, which is where a third party helps reconcile the differences between the two parties. This is most often used with insurance claim disputes, and an advantage of it is that it often preserves the relationship between the two parties after the dispute. Then arbitration is the resolution of a dispute by a neutral third party. Arbitration can be voluntary or forced, and there's a checklist of rules using the mandatory arbitration clause that is not unconscionable. An example of this is the clause is not buried in fine print and does not impose significant costs on the consumer. For selecting an arbitrator, arbitrators have to go by the Code of Ethics, and common uses are grievances under collective bargaining agreement, construction disputes, and real estate issues. Some issues associated with arbitration are unfair. It can be unfair because of the lack of diversity within arbitrators, because a lot of the people who use arbitration are women and minorities, and a lot of the arbitrators are white male 60-year-olds. A mini trial is an alternative dispute resolution method in which lawyers for each side represent the case for their side at a proceeding refereed by a neutral advisor, but settlement authority usually resides with senior executives of the disputing corporations.